Hi, my name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. Today we're continuing our video series designed to educate the public, so please subscribe to our channel. What about visitation with respect to an ex? Do you get to see your kid? Now, a lot of people say, well, what do you mean ex? You mean ex-wife? Ex-girlfriend? Does it make a difference? Well, for the purposes of this video at this time, the quick answer is it really doesn't. In other words, the ability and right to see one's child isn't tied to a marriage. So let's say you were unmarried and you had an unmarried relationship and the result was a child and the relationship is now ended. Do you get to see your kid? Of course, the answer is yes, you do. Now, it would be helpful. It would be nice, it would be in good faith if, even though it's an ex-girlfriend, the two of you sat down and had a good faith discussion and worked out a parenting time schedule where mom could see the kid, dad could see the kid. That would be the good thing, right? That would be the mature thing. In other words, even though the relationship is over, they're both still parents, even though they're not a couple, but they're parents and therefore they should try to work this out. What if you can't? What if the other side doesn't want to have anything to do with you? We get these cases all the time where somebody will say, you know, I had a relationship, it didn't work out, but now there's a pregnancy and they're not telling me anything. They blocked me. They created a scenario where I can't see the child. What do I do? Well, the answer is you have your lawyer file appropriate motions for parenting time. Your lawyer can file that motion even though you weren't married to her, even though there's no relationship. You're entitled to spend time with your child. You're going to be supporting that child to some degree. You're certainly entitled to spend time, have some appropriate parenting time, and it could be based on your work schedule, it could be based on school schedules, it could be based on your life scenario, and maybe it'll be alternating weekends, alternating holidays, but whatever it is, you're entitled to go before the court and say, hey, that's my kid. The paternity is shown that I'm the father. I want my parenting time. Now, if the paternity hasn't been established, it's a little dicey. In a marriage, there's a presumption of the paternity. But in a non-marital union, you could say, I'm the father. She'll say, no, you're not. And that's why I'm not letting you see parenting time. I have no proof that you're the father. If that's the case, again, you'll have to have your lawyer file a petition. But it won't be a visitation petition only. It'll be what we call a DP case, a petition to determine paternity. The court will order DNA testing. Once they do that and you're ruled in, then you will have the opportunity to have the appropriate parenting time. That's whether she cooperates or whether she doesn't. Let's remember one thing. At the end of the day, the one who makes the rules around here is the judge. So if the mom won't let you see your kid, you have the right to go before the judge, say, I'm the father, I want parenting time, and the court will have appropriate hearings and enter appropriate orders. If you have any questions about that, reach out. We'll be glad to help you out.